Thank you, my Lord. Before I come on to ground 1.8, I've managed to answer 2 out of 3 of my pieces of homework. First was a question from Lord Justice Holgate about where in Schedule 8 you see the provision that's made for the leaseholder, the LPI regulations, and that's Schedule 8, paragraph 12, which is page 81 of the Court Authorities bundle.
Yes.
And the other piece I can get back to you on, my Lord Justice Nugee asked me about where he might find the Building Safety Fund guidance. It's not a perfect answer, but it's probably enough. In the Adriatic bundle, additional bundle volume 2, there is Building Safety Fund guidance starting at page 660, and the relevant section starts at page 665 where it says what we will fund. Just one note of caution, that's the latest guidance as at April 24, not the guidance that was available at the time of the application. I doubt it makes a difference for present purposes, but
Thank you.
Tesco is what's left and I've not forgotten it. So ground 1.8, which is about the relevance of the changing identity of the ultimate beneficial owners of SVDP and Get Living. I've already made some submissions on this ground in the context of grounds 1.1 and 1.4, when I said that it's important to look at the reality of this case in 2 respects. First, it was the ODA who was the developer or associate of the developer when these blocks were being constructed. And you'll remember that was said to be irrelevant to the public first point. And second, when I emphasised that this application, or these applications, is all about obtaining a payment from Get Living. And as you see from paragraph 227 of the judgment, SVDP can only prepare its accounts on a going concern basis because of the continued financial support of Get Living. As I said, in no sense of the word could Get Living ever be described as the developer of East Village. It's the company that acquired the developer after the development had been completed. This is not the paradigm case where as I said, I think I said Selby Development, where a large property development company builds out a development using an SPV and then leaves it empty. And then there's also an important finding that I just ask you to glance at paragraph 172 of the judgment, page 183.
So the paragraph was
172 at page 183. And it's just the last 3 lines of that paragraph, please. QDDAV was the company that actually purchased SVDP Limited, which was the owner of SVDP. And you'll note the detail underpinning that finding is at paragraphs 167 to 172 of the judgment. The real point for present purposes is that SVDP was sold to entirely innocent purchasers. But then we see at paragraph 251 of the judgment, which is at page 197, we give no weight to the changing identity of the ultimate beneficial owners of SVDP and Get Living. And we say that was the wrong approach in circumstances where Get Living is sought to be made liable as an associate rather than as a developer itself. As you're well aware now, the provisions of the Act that make associates liable are a major inroad into the long-standing and well-known Salomon and Salomon principle. And it's because Section 124 allows the tribunal to impose a non-fault-based liability on an entity with a separate identity to the developer or the freeholder that we say the changing identity of the associate and all the circumstances of the association need to be taken into account when considering what is just and equitable. Now, the point the tribunal made here is that each of the investors who subsequently bought into the corporate structure above SVDP willingly assumed the risks associated with their investment. And if you'll note, that's paras 252 and 253 of the judgment. I've already addressed that point to some extent in the context of ground 1.5. The risks that they brought in included the package of rights against contractors and designers and so on. And they assumed those risks long before the Act came into force, when parents could not be liable for the acts of their subsidiaries. And of course, those rights that they bought cannot be pursued and determined within RCO proceedings. So that's my ground 1.8. As I told you, 1.9 was covered in 1.7 and 1.10 is covered under ground 1.4. So I should try and conclude ground 1.1, and I'd love to give you some very impressive piece of rhetoric. But I must confess, I can't do much better than refer you back to paragraphs 78 to 80 of our skeleton, which is at pages 34 to 35 of the core bundle behind divider 2. And just to conclude, I would say once due weight is given to all relevant factors, the appropriate order to make on the facts of this case is either no order now, but with liberty to apply for an RCO in the future, or an RCO now, but on terms that require SVDP and Get Living to pay for the remediation works following the conclusion of the Galliford Try litigation, whatever the outcome of that litigation. So, my Lord, unless you've got any questions on ground 1, I'll move to ground 2.
Yes, thank you.
Thank you. Starting with the so what, ground 2 relates to just over 1 million. It's £1,128,342 of Triathlon's additional claims that relate to costs that were incurred before 28th of June 2022. And to orientate you within the RCOs itself, that money sits within paragraph 1 of the orders. And in terms of where you go to in the judgment for consideration of ground 2, the overall discussion is at paragraphs 57 to 79 of the judgment, but the material conclusions are at paragraphs 73 to 79. And that's where the tribunal found that an RCO can be made in respect of costs that were incurred before Section 124 of the Act came into force on the 28th of June 2022. And as you know, we disagree with that interpretation. In terms of the relevant law, I don't think I need to address you, or at least take you to the authorities on the general principles of statutory interpretation. You've probably heard enough, but just to give you a reference, if only for formality purposes, you can see the decision of O and Secretary of State at paragraphs 29 to 31, which is in the core authorities bundle, tab 8, page 140. The essential principles are this. The process of construction is an objective assessment of the meaning which a reasonable legislature would be seeking to convey. The primary focus is on the language of the statutory provision itself, read in the context of the section as a whole, and in the wider context of a relevant group of sections. And in relation to retrospectivity, we adopt the summary of the law at paragraph 61 to 62 of the judgment. In short, Parliament is presumed not to intend to enact legislation which has retrospective effect, unless an intention to do so is clear. And when considering whether such an intention exists, it's necessary to consider the degree of unfairness that the retrospectivity would cause. The greater the unfairness, the clearer the intention that is required. Now, can I start just by helping you to understand how the issue of retrospectivity can arise? I'm not saying this is how it arises on the facts of this case, but it's important not just to test the point by reference to the facts of this case, but the actual how the provision, section 124, could bite. And we saw when we looked at section 1243, if you want to have it open, it's For Authorities, tab 5, page 89. So looking at subsection 3, we see that an RCO can be made against a landlord. And we looked earlier at the definition of interested person, and over the page at little e, that includes a person with a legal or equitable interest in the relevant building or any part of it. In other words, it can include a tenant. Thus, a landlord and tenant can have entered into a lease before the 28th of June 22. The landlord can have made a perfectly valid service charge demand before 28th of June 2022. And the tenant can have complied with that demand through payment of the monies requested before the 28th of June 2022. But on the tribunal's interpretation of section 124, the tenant can then turn around to the landlord after 28th of June and claim the payment back from the landlord through an RCO. We submit that that is a classic case of retrospectivity that would engage the presumption against retrospectivity, because the RCO is being used to unravel a perfectly lawful transaction that has already been completed. So the question which the tribunal has to consider is whether the language of section 124 is sufficiently clear to have intended that result.
Well, it's partly from the language of section 124, partly from any other relevant language in the statute and the purpose of the statute as a whole.
Yes, but of course you start with the language of the provision itself, and then we'll work through. So, starting with the language of the provision itself, the key phrase, which I'm sure you've got in your mind, is at section 1242, and it talks about meeting costs incurred or to be incurred. And the tribunal said, well, that was sufficient of itself to be clear enough to apply to costs incurred before the Act came into force. We say that those words are not sufficiently clear to displace the presumption, because, just starting with the language itself, costs can be incurred both before and after section 124 came into force. In other words, all 124 is saying is that you can apply for an RCO both before and after you incur the costs of remediation measures.
So is it, on your reading, is it entirely prospective? It only applies to costs incurred or to be incurred after the date it came into force?
Yes. So that's the language of the provision itself. Let's look at the wider provisions.
Yes, but before we move on,
Yes.
on that, if that's what Parliament was trying to do, all it needed to do was to say incurred. If it only has prospective effect, the single word incurred would have been enough.
My Lord, I disagree because it's costs incurred. And so if you're looking at future remedial costs, then they're not costs incurred, they're costs to be incurred.
I suppose it's the to be incurred might be there to cover on account.
Well, on account, or I'm about to enter into this building contract with Erigal, I need £20 million to pay them, or whatever the sum is. So I am entitled under Section 124 to claim those costs because they are costs.
I beg your pardon. Yes.
To be incurred.
Yes.
That's
yes, I understand.
So, looking at the broader provisions, the first point that's made against me is the definition of relevant defect. Because we can turn it up if necessary, but you might have seen the point already. It's defined in section 120 at page 23, and it's defined as a defect which causes a building safety risk in work that was carried out in the period of 30 years before the 28th of June 2022. And so it said that 30-year feature, or the looking back, as I think some people refer to it as, is said to define the temporal ambit of section 124. I disagree that definition assists, because section 124 came into force at a time when plenty of buildings still needed to be rectified. I think you heard in Adriatic, initially the plan was to let the industry work it out for itself, and it wasn't doing that, so Parliament had to intervene. Why did it intervene? To get the work done. And of course that remains the position. There are plenty of buildings that still need to be rectified, and you got the sense of that from the letter we looked at from the Secretary of State from late last year. So section 124 still has a huge role to play in respect of costs incurred after the 28th of June 2022. And I'd go further, because I submit that the definition of relevant defect in fact highlights the potential unfairness, the unfairness of a retrospective application. Because a retrospective application affects completed transactions going back almost 30 years. And the Secretary of State says, and if you'll note that's paragraph 31 of their skeleton, that they try to dilute this point by contending that it's already a feature of residential service charge legislation that leaseholders may be able to challenge payments made a considerable time ago. In my submission, that misses the point. And that's because landlord and tenant law has never said that a leaseholder can recover service charge which has been paid and was payable at the time it was paid. The situation here is different in that service charge was payable at the time it was paid, but a subsequent change in law, in particular Schedule 8 of the Building Safety Act, says that service charge is no longer payable. So that's what I had to say about relevant defect. Then if I can look at other provisions, and you'll remember I touched on those provisions earlier, and I promised I'd come back to them. Now is that time. So going back to the Building Safety Act, the first one is Section 130, the provision that provides for building liability orders. And that's at page 42 behind divider 4 of the authorities bundle. So the building liability orders are the orders which allow the court to impose a liability on associates in respect of liabilities of of related companies under the Defective Premises Act. I'll just go through the full list. So page 42, subparagraph 3 is where they define relevant liability. So you've got the Defective Premises Act, which we've talked about. Then Section 38 of the Building Act 1984. Just for your note, that's not in force yet. But that is the provision that could impose civil liability for breach of the building regulations. Or as a result of a building safety risk. So, for example, that could impose liability on associates of product manufacturers. Their products give rise to a building safety risk. Now, the important point I wish to make for present purposes, retrospectivity, is still at subsection 3. Relevant liability arises, can you see the text in parenthesis? Before or after commencement. And then moving on to page 51 is where we come to section 135, the provision that extended the limitation period for Defective Premises Act claims to 30 years. Just where do you see that? You see at subsection 1, they introduce a new section 4B of the Limitation Act. And then at what would be subsection 4B, subsection 4, says where a person became entitled before the commencement date to bring an action against any other person, this section applies as if the reference to 15 years were a reference to 30 years. So this is the clear provision that not just gives a longer period of 30 years, but makes clear that it applies retrospectively. And
Sorry, I wasn't keeping up. Where were you reading from?
Sorry. So, section 135, subsection 1.
Yes.
New section 4B.
Yes.
Subparagraph 4 is where they introduce the 30 years.
Yeah.
And then if you read subsection 3 of section 135, yes. That's where it says, is to be treated as always having been enforced.
Yep.
So that's how it's clear it's retrospective. And then just while we're looking on this, I would also point out, if you turn over the page at subsections 5 and 6, there are safeguards in relation to that retrospective application. The first is if the pursuit of the claim would involve a breach of human rights, at subsection 5. The second at 6 is where the claim has already been settled by agreement between the parties or finally determined by a court or arbitration. So just looking at those two sections, section 130 and 135, I derived two points. First is that the Defective Premises Act was seen to be an integral part of the change of law brought in by the Building Safety Act. Second,
Sorry, let me keep up with you.
I'm sorry. I can probably slow down a little, believe it or not. So first, DPA was seen to be an integral part of the change of law brought in by the BSA. Second point, when the Building Safety Act intends that certain provisions have retrospective effect, we see that it says so very clearly. And we see that particularly from the language of sections 130, subsection 3, and 135, subsection 3. And we also see it when we come on now to section 149, please.
Can I just ask, it may not matter, but the defects that are brought within the scope of this Act go back over a period of 30 years, going back from 2022. Take, for example, the 1972 Act.
Yes.
The new limitation period is substituted for the old in that Act. Why did Parliament express this in terms of as if it had always been enforced, given that the defects could only go back to...
Because the concept of a relevant defect is a Building Safety Act concept, not a limitation, not a Defective Premises Act.
Well, I appreciate that, but yes, I see.
And so the liability under the Act is, perhaps we could just look at that.
Yeah, I see. I think I see what you... Well, in that case, yeah. Well, that's why you then need to have those explicit words, because it's going beyond the reach of this Act as such and the new provisions it's introducing. It's explaining how the limitation Act, the limitation period in the DPA is going to have to work.
Yes.
It's dealing with the cause of action which arises under that legislation.
Yes, it is. But my point is that amendment is being made as part of the package which is within the Building Safety Act. And when it wants something to have retrospective effect, and this is part of the Building Safety Act, albeit an amendment to another act, it does make that very clear. And you also see it in the context of building liability orders, which are a right under the Act.
Yes.
And as we're about to come on to, we'll see that in section 149, which is at page 57 of the authorities, core authorities. So section 149, it is the provision that makes product manufacturers retrospectively liable for what they call past defaults relating to cladding products. So it's not every construction product, that comes in at section 150. This is just cladding products because, of course, cladding is the main concern arising out of Grenfell. And we don't need to get into the detail of section 149. What you see from subsection 1 is you've got to satisfy 4 conditions, what they call A to D, and then subsection 2, condition A, it says at any time before the coming into force of this section, the manufacturer failed to comply with the cladding product requirement and so on. Again, makes it clear before the coming in to force of this section. And you see the focus here is on misleading statements, inherently defective products, and so on. And so sections 130, 135, and 148 are provisions within Part 5 of the Building Safety Act which are fault-based. Or at least they relate to fault-based liability under the Defective Premises Act. As I said earlier, these are the provisions which ensure that those responsible for relevant defects are held to account. And what these provisions show is that a person who has incurred costs before 28th of June 22 is not left without a remedy if my interpretation of section 124 is correct. Someone who's incurred costs before 28th of June may not be entitled to an RCO, but what they can do is seek damages under the Defective Premises Act, or for breach of the Defective Premises Act duty, and they can also seek damages against the cladding product manufacturer under section 149 of the BSA, and they can also make associates liable through building liability orders under section 130. And as you'll remember, the Defective Premises Act imposes obligations on developers. Section 1.4. And so one of the premises underlying the tribunal's analysis, which is that leaseholders would have no remedy if section 124 didn't apply to costs incurred before 28th of June, is wrong in my submission. They wouldn't have a remedy under section 124, but they would, as we've seen, under the Defective Premises Act and section 149 of the Building Safety Act. And as I've said, that remedy is a remedy against developers. So even when we're thinking about people in hierarchies and so on, the developers are still in the firing line. And in the same way that associates of developers can be made liable under section 124, associates of developers can be made liable under building liability orders. And actually the test for association, it is a broader test. But that might be a point of detail. Now, probably what's on your mind is the relevance of Adriatic land in all of this. So let me address you on that. True it is that the issue in Adriatic is whether Schedule 8, Paragraph 9 applies to costs incurred before 28th of June 22. However, Adriatic does not address the meaning of the words incurred or to be incurred. And so we say it doesn't address the point in issue in this appeal. Rather, the relevance of Adriatic is to the construction of section 124 in light of the other provisions of the BSA. In other words, what we talked about and I've heard discussed previously, how it fits into the overall scheme. In terms of that overall scheme, what I say is you have Schedule 8 does what it does, and I think as you've identified, not all leaseholders are protected by Schedule 8 if they're not qualifying leaseholders. They still have a right to claim under section 124, but that's only in relation to costs incurred after the 28th of June. And the next part of the scheme is costs incurred before 28th of June. They have to be pursued by reference to the other remedies available, Defective Premises Act, section 149, and so on.
So where we end up is that if you've got leaseholders who are homeowners,
yes,
then they will be liable for service charges.
So when you say
they will be liable for the service.
So when you say homeowners, do you mean
the
more than 3 properties?
Yes, you know exactly what I mean. The qualifying leaseholders.
Oh yes.
They're people who are living in their own homes.
Yes.
They will not have the protection of Schedule 8. They won't be able to rely on Section 124. Instead, they're going to have to start litigation.
Yes.
Under the Defective Premises Act and so on.
Yes. So that is my submission on Adriatic. One, doesn't leave, the system works, and two, it's different language. And I know incurred or to be incurred does feature in paragraph 10 of Schedule 8, as you saw. But in that sense, we adopt the finding of the FTT in Adriatic that Schedule 10 is parasitic. I'm not sure if that's the language of the Act, but parasitic. Paragraph 10 is parasitic on paragraph 9. So the real question is payable, rather than what is the meaning of incurred or to be incurred. Now, I next need to address the point, this point, which I call the just and equitable safety valve point. What do I mean by that? It said, well, under section 124, an order will only be made if it's just and equitable to make the order. So if you're concerned about fairness and the fairness of an order being made in respect of costs incurred before the Act came into force, don't worry, just and equitable is the answer. I disagree and submit that the just and equitable requirement in section 124 is no real safety valve at all. And that's because if the decision of the FTT below is correct, the answer to just and equitable arguments in this context will almost always be that Parliament has taken that into account, retrospectivity into account, when deciding that an RCO could be made in relation to costs incurred before 28th of June 22. And that indeed is an approach that the tribunal itself adopted at paragraphs 281 and 282 of the judgment. Maybe you should look at that at page, core bundle, tab 11, page 204.
Sorry, that was paragraphs
281 and 282.
I think the argument we're making is a fairly straightforward one, that if you interpret the Act as applying to those costs, it becomes part of the purpose of the Act.
Yes, and as the tribunal there said, yes, in the opening of paragraph 282, it's difficult to think of an example of such circumstances where it would be just and equitable not to make an order.
I was finding it a little bit difficult to see how it's just and equitable to refuse to make an order on the grounds it goes against the purpose of the Act.
Yeah. Just for your note, similar points arise at paragraph 286 and 289 of the judgment. And I would add about the effectiveness of the just and equitable safety valve, such that it is or isn't. There are no clear safeguards regarding retrospectivity, such as those which exist at section 135, 5 and 6 of the Building Safety Act. We looked at bringing in the retrospective amendment to the limitation period, the 30-year limitation period, human rights, and case already determined, either by settlement or judgment. Now, it's said that those safeguards would by definition be situations where the just and equitable requirement is engaged. But all I can say is maybe. But the fact that they are not expressly stated does mean that it's not necessarily so. And you just need to make some minor tweaks to the facts of the Vista Tower number 2 case to understand why. There's been 2 Vista Tower judgments, so just to explain that. Vista Tower number 1 was an application for a remediation order by the Secretary of State, and that's the judgment that appears in the core authorities bundle at tab 12. Vista Tower number 2 was an application by the freeholder who'd been made liable for the remediation order against the developer and a number of associated companies for an RCO. And that judgment features in volume 2 of the authorities bundle in our case at tab 22. And what was said in Vista Tower number 2 was, well, what the developer said was, well, I sold the building to you, and there were limited warranties in our agreement, and you knew you were buying from an SPV, and the only security you had in relation to that was that our agreement contained a retention, and you've had the full value of the retention. You shouldn't have it's not just and equitable to be given an RCO. Contract is king, if I can put it that way. But the catch in Vista 2 was that the tribunal found that there was some kind of misrepresentation by the landlord, and also that the warranties given were breached. And so the tribunal decided to ignore the terms of the agreement and found that it was just and equitable to make an order in respect to the full amount. So in the same way that the FTT in that case decided to ignore an agreement, you can see that there are circumstances where another tribunal might look at a settlement and say, well, I don't consider myself bound by it, and I don't consider it not just and equitable to refuse to make an order, given that there was some kind of misrepresentation or given the nature of the defect. So they're my submissions on safety valve. Explanatory notes. Again, I'm very conscious that you've heard lots of submissions about that. Let me, and the relevant paragraph of the explanatory notes relied upon in this case.
And this is in the final version?
Yes.
Do we know what explanatory notes were before Parliament as the bill was going through?
It's paragraph. The answer is I don't know. No, but I think this is the same section that you were looking at during the course of the Adriatic proceedings, because it all relates to Part 5.
And I quite follow that. I think it's right that the particular bits we were shown were specific to Schedule 8.
Yes.
I quite follow that the whole of Part 5 was anew. If it were possible to identify what had been before Parliament in relation to Part 5 more generally, that would be interesting. Yes.
I should confess from the outset that I made a concession below that the explanatory notes, that I didn't make the distinction that I know is now before you. I accepted that they were relevant.
I'd be a bit surprised if we decided that was determinative in circumstances where we're not just deciding the rights and wrongs as between the parties before us, but the construction of a provision of much wider importance.
My lord, I just thought it was only proper that I
Yes.
should raise that. And I'm not going to get too bogged down, if I can put it that way, on that point, because I make 3 points.
So it's 10-12, did you say?
Yes, paragraph 10-12 with the explanatory notes, which I will take you to
Yes, I see.
in a second.
Yeah.
So 3 points. First is, as is correctly recorded at paragraph 53 of the judgment below, explanatory notes play only a secondary role as external aid to interpretation. And what I adopt is the paragraph in Benyon at section 24.14, which is that the weight to be accorded to the notes should depend on the cogency of their reasoning. I don't know if you need to look at that for present purposes.
Might just turn it up.
Yes, so it's tab 15 of the core authorities. And it's the section starts at page 414. Sorry, 413. And then the part that I rely upon is at page 416. And if you start at the top, you'll see there's an italicised heading which says which versions of the notes may be used. And then I rely on the second paragraph, which starts the explanatory notes of the Act, post-date its enactment, and so on. And then at the very end of that paragraph is what I rely upon. In other words, the weight to be given to them should depend on the cogency of any reasoning contained in them.
I mean, to be fair, I think that's dealing with notes that post-date the enactment.
Yeah.
Well, it's true of these explanatory notes as we had them now.
Yes.
I think. But if there had been things before Parliament, then that comment wouldn't obviously apply.
No. I think Sir James put it yesterday that the explanatory notes command such weight as their content will bear. I think that was the phrase that I would agree with.
Because there's no authority for this passage in Benyon. I'm not sure I understand what's meant by the cogency of any reasoning. I mean, what function does that then impose on the court to assess the merits of the legislation? Can't mean that.
I think it could be that. It goes back to Mr. Justice Lloyd Jones. If it's got the status of an academic article, then you worry about the cogency of the reasoning.
Yes. Can I put it this way by reference to the paragraph that we're relying upon?
Yes.
Rather than talking in the ether, as it were. So the relevant paragraph 1012, that's behind tab 14 of the bundle at page 393. And so it's the top paragraph 1012. And so you see what's relied upon against me, that example, if leaseholder contributions are required under Schedule 8 or if they've already paid for the coming into force of the leasehold protections they may wish to seek to recover.
Yes.
And that's as an example of cogency of reasoning, or what weight does that note bear? I would make these points. If you read the paragraph as a whole, the focus of the paragraph is on the ability of leaseholders to seek an RCO. The focus of the paragraph is not on retrospectivity.
Well.
Who wants to go first?
I think the words already
before they're coming into force, do focus on retrospectivity.
Well, sorry, they certainly address retrospectivity, but my point is more, if you look at the focus of what's the paragraph seeking to address, it's not seeking to engage with this, if I can put it this way, knotty question. It's a passing reference. And you'll see that more if you have a bit more luxury of time to read the paragraphs that precede it. But yes, I have to accept, it says there expressly costs, paid costs before the coming to force of leaseholder protection. Yes. But I don't think that's sufficient, bearing in mind that your focus should be on the language of the Act when read in the context of the other provisions and the statutory purpose. It even uses the word may rather than is entitled to. Now, I saw your eye roll, so
Well,
but you can take that another way. I recognise.
It's not meant to express diffidence about what they're trying to convey, and there's not much point giving this explanation if there's no power or legal ability to make use of it.
I see that in relation to my point about the word may.
Yeah.
But as I say, this is, to use other judicial language, too slender a thread to rely upon, set against the language and the points I've already made. Because in my submission, if you're having to resort to the explanatory notes to interpret section 124, it must follow that the language of the clause itself is not sufficiently clearly expressed to demonstrate an intention that the clause has retrospective
That was really the
effect.
point I was trying to raise yesterday morning. You're supposed to be able to find language which is sufficiently clear to overcome the presumption in the Act itself. It's only through the Act that Parliament expresses its will. It doesn't express its will through explanatory notes. So if you're resorting too much to explanatory notes, you might be said you've got a bit of a problem.
My Lord, I would respectfully agree.
So I don't find explanatory notes very helpful.
Quite.
On that issue.
Yes. There, of course.
I mean, it would be, on the other hand, forensically, if they went the other way. But that's a different question.
Yeah. It's a bit like those cases when you're trying to interpret a contract and people start bringing in all the background material and the court says, what do I need to see that for? It's got, in my submission, that flavour.
Going back to the cogency of reasoning point,
Yes.
I was thinking by way of an analogy, Pepper and Hart, when you
Yes.
look at a statement by a minister responsible for promoting a bill. We don't look at the cogency of the reasoning. What we look at instead is the clarity of what is being said.
Yeah.
And unless it's clear, high authority says you don't take it into account. I find that a slightly easier concept to grasp if we're looking at explanatory notes.
Yes. And of course,
That's what I was struggling to say.
yeah. And of course, no one suggesting that we're in a Pepper and Hart territory.
No, but given the limited way in which that can be used,
Yes.
and that's coming from the horse's mouth, or a horse's mouth, when you come to explanatory notes, you wouldn't expect the approach to be lax.
No. I'm nearly there. I may not be. We're 7 minutes past, or 6 minutes past.
Exactly. I'm sure you've used. No, you haven't used up your. Well, maybe you have used up your 7 minutes. I'm not sure.
I might buy 3 minutes off my learned friend. He's feeling very generous, he tells me. So I just had to address you briefly on the relevance of Loughborough and the amendments brought in by that. I think, as you will have seen, they have more import in relation to ground 3 rather than ground 2. But I should deal with it anyway because it features in the skeletons. So two relevant statutory provisions, section 116 of Loughborough and section 117. In our supplemental skeleton argument, we relied upon section 116, which is the source of the amendments to section 124. So section, just to give you the, Luff is in the Triathlon Authorities, Volume 1, Tab 2. And section 116 starts at page 11. And so section 116 you see from subsection 1, these are the amendments we're making to section 124, and they brought in various amendments, particularly we would say broadening. I think my learned friend would say making clear, but don't worry about that. What are the relevant measures or works in respect of which you can obtain a remediation contribution order? And the only point we make for present purposes relates to subsection 7 over the page. And you see how, again, the amendments made by this section apply. Subsection A related to pending proceedings. B is what I rely upon for present purposes in relation to costs incurred before as well as after those amendments come into force. And we just have 2 points on this. First is the point that I've already made by reference to the other provisions of the BSA, where Parliament intends for provisions of the Act to have retrospective effect. It says so in much clearer terms than we see in section 124 itself. And the second point follows on from my first. If the tribunal's retrospective interpretation were correct, there would be no need for section 116(7)(b, because incurred does the necessary work.
Oh, as the BOTOs?
Yeah.
Yeah.
But does your interpretation require reading 7b as if it means now? In relation to costs incurred before the 31st October 2024, but not before 28th of June 2022?
No, because this if you read the introductory language to subsection 7, it's the amendments made by this section apply.
Yes,
So it's only applying to the extent to which the amendments are in force rather than the underlying provision.
But 2a little a includes costs incurred in taking relevant steps in relation to a relevant defect. Is that not one of the amendments made by the section?
Yes, it might help you to read it in context. Can I ask you, though, to keep this bundle open because I need to just finish with section 117. But have a look at where those amendments fit in. So tab 4 of the core authorities bundle at page 30. And you'll see that the amendments are inserted in square brackets. But the operative provision at 1242 remains that it's meeting costs incurred or to be incurred in remedying. And what they added was, or otherwise in connection with, relevant defects. And then the purpose of subsection 2a, which is what you were looking at, my lord, is this. where it says the following descriptions of costs, among others, fall within subsection 2, and then it explains them. So the relevance of that provision that you were asking me about, it is in 2A, it's just setting out what are examples of costs that fall within the scope of a remediation contribution order.
Yes. I haven't expressed this point at all well, because it's only half form. Your submission is that prior to LUFRA, the words costs incurred or to be incurred in subsection 2 meant after the coming into force, after 28th of June 2022. Then LUFRA comes along, it adds subsection 7.
Yes.
And it says the LUFRA amendments apply to costs incurred before 31st of October 2024.
Yes.
Do they apply to costs incurred before the 28th of June 2022?
Well, I say the answer to that question falls on a proper interpretation of section 1242.
So your answer is no, they don't. They don't.
No.
So I was right. The practical effect of subsection 7b as inserted by
It's not inserted.
It's not inserted. I'm sorry.
No.
The practical effect of 7b of section 116 of LUFRA is that amendments for things like waking watches and so on
Yes.
apply to costs incurred before the 31st of October 2024, but nevertheless not those incurred before the 28th of June 2020.
And that's because subsection 2A is still subject to subsection 2, which is not affected by LUFRA, other than for that slight amendment of
In which case one might have thought that subsection 7b of LUFRA is slightly misleading because it appears to say this is retrospective, but it doesn't really mean that. It means this is retrospective for a couple of years. That's what it really means.
Yeah.
Yes. Okay. Thank you.
So I've just got to pick up section 117 of LUFRA, which back in the Triathlon Authorities bundle, volume 1, tab 2, page 1313. And this is really just addressing, section 117 is an amendment to Schedule 8, paragraph 9, which you have been looking at already. And all I wanted to draw to your attention was subsection 4 over the page, where it says something different. The amendments made by this section do not apply in relation to legal or other professional services provided before this section comes into force. So this is an example of a situation where not every provision of the BSA is backward looking. And so we say it supports our position that section 124 does not need to be interpreted retrospectively also, because it's just not the case that every provision has full retrospective effect.
You have got the case law, I think you've been given it somewhere, about the use of subsequent legislation to interpret prior legislation.
Yes.
And again, you only go to it if there's an ambiguity in the prior legislation.
Quite. You'll see where you go with it. But I thought I should be comprehensive at this stage, where I just about had the time. My lords, it just leaves me to wrap up on ground 2. I say this: you have to look at the competing fairness of the rival interpretations. If Section 124 is applied to payments made before the 28th of June 22, it has a 30-year reach and gives respondents, such as landlords, minimal defence. Because, for the reasons already explained, the just and equitable requirement will not be much of a safety valve. Whereas, if it's only applied to payments made after the 28th of June 22, leaseholders are not left without a remedy. They are only unable to pursue recovery under Section 124. They can still pursue recovery under the DPA and section against including developers, and they can pursue recovery under Section 149 of the BSA, including for a building liability order where appropriate. And that will be against people who are at fault, rather than potentially against those who are not in any way at fault, such as what you might call entirely innocent landlords. Accordingly, we submit that the interpretation of Section 124, so that it does not apply to payments made before 28th of June, leads to a fairer and more appropriate outcome, which is more consistent with the presumption against retrospectivity. My Lord, those are my submissions on ground 1 and 2, unless I can help you any further at this stage.
Thank you very much, Mr. Selby.
Of course, I'll come back to you on Tesco, but I'll probably do that in my reply.
I say so. It's more a question of whether you can find an authority to support the proposition that when a tribunal says no weight, it means irrelevant.
And of course, I will give my opponents notice. Thank you.
Mr. Simpson.
Good afternoon. I'm going to obviously start with ground 1, which I won't complete this afternoon. How to approach the question of discretion will obviously be a matter entirely familiar to this court, and certain indications in that regard have already been given. It's common ground how the question of a discretion should be approached at first instance. That's the AEI rediffusion case that my learned friend referred to and described this morning as uncontroversial, and so that's the straightforward element of this part. The position on appeal, I think, also accepted at least to a point. We've cited, I think, 3 authorities in relation to the nature of the exercise that this court should undertake. Forgive me for having done so in a little detail and doing so now. It's because this is a new provision, I think it is perhaps worth mentioning in a little detail. The first case is G&G, which is tab 4 of our authorities. I would certainly invite you in due course to read from the speech of Lord Fraser, pages 58 and 59, which are sidelined. I'm not going to read them out. It's the case of G&G.
No, I've got the passage. I'm just confused by the 58 and 59.
Apologies. It's the pagination at the bottom.
I must be looking at the wrong thing. Mine says 139 and 140.
Not a promising start. Right, I'll have to look at that overnight. I'm not sure why my bundle is therefore good.
For what it's worth, my bundle does say page 58 and page 59, but the index to my bundle has it starting at page 135, so there is obviously some confusion.
Yes.
But it's 651 of the original.
It is. It's page 651.
No, I've had no trouble identifying the passage. I was only confused by the page number.
Yes. Well, I'm not sure what's happened there, but I'll try and sort something out overnight.
And it's really, Lord Fraser's really just citing Lord Justice Asquith.
As I said, it's very well known, but it's and it's applied again by the Court of Appeal in tab 7 by Lord Justice Brooke, and I will use the original pagination of 1317 at tab 7, where he picks it up again and refers to the phrase we've relied on, exceeding the generous ambit within which reasonable disagreement is possible. And learned friend also relied on Carroll and Chief Constable, which is at tab 15, and again, I won't take you to that, but it says much the same. So that's the general approach, appellate approach. We would respectfully endorse Justice Holgate's reference to Tesco in relation to the weight point. But I do also want to deal with the specialist tribunal point too, which is a further gloss on the role that this court performs when reviewing an exercise of discretion, when the discretion has been exercised by a specialist tribunal. Our submission is that the appellate role is, so to speak, even more limited or more deferential to the first instance decision of a specialist tribunal. Jones and the FTT at tab 12 of the Triathlon Authorities is a case from the Supreme Court. I can get quite a lot of what I want to say from the head note, which is on page 49 of the original numbering, in the per curiam summary at paragraphs D to E, starting where the interpretation. If I could just ask you to read the whole of that paragraph.
Yes.
And then go please to paragraph 16, which starts on page 56 of the copy, but I'm going to take you to page 57, between paragraphs A and B, or, where it says in the third line, I agree with Lord Carnworth for all the reasons he gives, ... And then this, a pragmatic approach should be taken to the dividing line between law and fact, so that the expertise of tribunals at first tier and that of the upper tribunal can be used to best effect. An appeal court should not venture too readily into this area by classifying issues as issues of law which are best left for determination by specialist tribunals. And then at paragraph 41, on page 63, the sidelined passage which says, whereas here, it's paragraph C, whereas here the interpretation and application of a specialised statutory scheme has been entrusted by Parliament to the new tribunal system, an important function of the upper tribunals to develop structured guidance on the use of expressions so as to reduce the risk of inconsistent results. And then paragraphs 45 and 46, Lord Carnworth refers to an article, I think, an extrajudicial article of Lord Hoffman's under the heading of Fact and Law, and you can read the section which is referred to from there, which includes the expression just above G. It's a question of degree on which the decision of the primary fact finder is entitled to considerable respect. And then over the page, at page 65, you can see what Lord Carnworth has to say about what Lord Hoffman had said, and the deference that's given to the tribunal entrusted with the statutory role. So far as reasons are concerned, this is just a small point, but at various points in his skeleton, perhaps less so today, the learned friend has criticised the quality or level of reasoning given by the tribunal for its decision. Now, we would obviously say that none of those criticisms is justified. I can't help but observe that this decision runs to nearly 300 paragraphs over 58 detailed pages, which is not short on reasoning. But if material, we would draw to your attention paragraph 25 of Jones. It's a slightly different point, but while we're looking at the authority, it's paragraph 8 at the bottom. It's page 59 of the original report, letter H. It is well established as an aspect of tribunal law and practice that judicial restraint should be exercised where the reasons that a tribunal gives are being examined. The appellate court should not assume too readily the tribunal misdirects itself just because not every step in its reasoning is fully set out. That may seem a little defensive to be relying on so early, but it's just because we're looking at Jones at this point. Then the last authority on this theme, what I wanted to rely on, was FCA against Seiler, tab 20. So that's in the other triathlon volume. Now, we may struggle here. But let's see how we get on, because there aren't any. My first page of that is 427.
Yes. Yes.
Bingo. Right. So this is Lord Justice Fraser in the first instance. It's an appeal from the Upper Tribunal Tax and Chancery Chamber, and it was an issue about costs. The Upper Tribunal had decided in the exercise of its discretion to award a proportion of costs to the successful respondents. One can get that from paragraph 2, page 428. The threshold condition to the exercise of a discretion was unreasonable conduct. And so it was a condition precedent to the jurisdiction to order costs that there had been unreasonable conduct. That's paragraph 19. And the Upper Tribunal had concluded that the threshold condition had been met. That's paragraphs 19 and 28. And the ground of appeal, relevant for today's purposes, related to that conclusion. And paragraph 36, Lord Justice Fraser, this is on page 438, paragraph 36, Lord Justice Fraser says, this, i.e. whether someone has acted unreasonably, is an evaluative assessment that can only be reached after detailed analysis of the facts. Upon appellate review in any type of case, the court would generally not interfere with the conclusion of the court below on findings of fact. And so what we're saying here is, well, the exercise of discretion, which the First Tier Tribunal exercised in our case, involved, in effect, two steps. It involves making primary findings of fact, and then there's an evaluative assessment, just and equitable in our case, acting unreasonably in the other case. But that evaluation is itself, in effect, on the to be regarded more as something to which weight should be given to the original tribunal's decision. And one can see Lord Justice Fraser repeating the same theme along those lines at paragraphs 43 at page 441, where he refers back to the pragmatic approach of Lord Hope, which I have taken you to. Paragraph 53 on page 443, returning to the pragmatic approach. And paragraph 89 at page 450. What was the decision one within the range of decisions which the tribunal was entitled to make? And then Lord Justice Lewison, at page 459, paragraph 137, he agrees with Lord Justice Fraser, but then he he adds some paragraphs at the end on page 460, which we also rely on in full. I won't read them out. And that leads to the submission that we make at the end of paragraph 19 of our skeleton, that we invite this court to send a robust message out that this court would not likely interfere with decisions made by a specialist tribunal in respect of Building Safety Act applications, particularly ones involving the exercise of discretion. There was a brief discussion this morning about the level of expertise of this tribunal, given that it was, so to speak, the first case of its kind. But I would respectfully submit that that tribunal has huge experience in the field of property law. Of course, the statute is new, but it engages with the complex interaction between leaseholders, landlords, developers within the industry and the ramifications that it has. And that is well within its field. And expertise. Developers are not unknown to the First Tier Tribunal. My junior suggested, by way of example, applications by developers to release restrictive covenants under the LPA 1925 would be a commonplace interaction of the developer with this. So it's not a wholly new area. Obviously, I would also pray and aid the particular expertise of the two individuals who comprised, unusually in this case, the First Tier Tribunal, as being of great experience. I mean, it is not a coincidence that it was the President and Deputy President of the FTT. And part of the consideration, not in this case, as it turned out, but in many cases, will involve things like the impact on tenants. We led some evidence in relation to that. You may well have seen it's paragraphs 231 to 234 of the FTT's decision, where they comment on the effect that these issues were having on the tenants. They said that they didn't need to depend, their decision didn't need to depend on it, because in this case the works were being done, but they could well see that that type of evidence would be material in another case. So that, again, it's showing a level of awareness and expertise unique to that tribunal. So much for reviews of decisions. The other introductory point I wanted to make in relation to ground one before turning to the individual heads is the one I made at paragraph 9 of my skeleton, which is this. Ground one, as your lordships know, is an appeal based on the what is said to be the inappropriate exercise of discretion in relation to the remediation costs. That's the errigal building contract, essentially. Ground 2 and 3 related to the money that my clients had been asked to expend, and grounds 2, which is ground 2, is challenged on retrospectivity grounds. Ground 3 had been challenged on what I would call scope grounds. In other words, the costs were outside the Act. That's now accepted, must fail, the basis of the concession being the new legislation. But the point I wanted to make is that grounds 2 and 3 were not challenged in this appeal on discretionary grounds. It wasn't said, and isn't said, that those sums should not have been awarded to Triathlon as an exercise of discretion. They were both jurisdictional objections. We observe that is a curious feature. My learned friend justified it this morning by saying, well, they weren't dependent on building safety fund issues, and by contrast, ground 1 was. But we don't respectfully see how that works. If it's not said because in grounds 2 and 3, it's not said to be unjust or inequitable that SVDP as developer or Get Living as its associate should pay for those costs. And we invite you to consider that when you are evaluating the outcome in ground 1. The principal point that is made, obviously there's a number, but the principal point in ground 1 is that the works are fully funded and underway. And as I said, my learned friend Mr. Selby distinguishes ground 1 from grounds 2 and 3 because grounds 2 and 3 were not building safety funded. But in respect of the additional claims, which are the basis of grounds 2 and 3, the money has already been spent and the work undertaken. The professional fees which were incurred in order to set out the scope of work that became the subject matter of ground 1 had already been spent. So in one sense, the fact that the work had been done and the money spent is an a fortiori case. It makes the basis for ground 1 in our submission an unreliable one once the concession has been made in relation to grounds 2 and 3. Those are the two sort of introductory points I make in relation to ground 1. I then want to come obviously to the 10 individual grounds. Ground 1.1, my learned friend's contention is that the FTT effectively created a presumption that an RCO should be made in every case against the developer. There are three fundamental difficulties with that submission. The first is that the decision at paragraph 237, which is, let's just take your lordships to the decision. I'm using the core bundle tab 11 as opposed to the version of the authorities. It's page 194. Paragraph 237 reflects in our submission the FTT's awareness of the breadth of the jurisdiction and no presumption is included in it. As if that were not enough, at tab 12, you will find the remediation orders that were in fact made tab 12 in the core bundle.
Yeah.
And for you will see at page 212 that within the order was the permission to appeal, which ultimately ends up before this court. And in seeking permission, my learned friend had formulated, I think almost exactly, but certainly pretty close to the grounds of appeal you now have. And it's important to look at what the tribunal themselves thought of the point that they had effectively created a presumption. It's paragraph 6 on page 213. And they say this 4 lines up from the bottom. Ground 1 challenges the tribunal's exercise of its discretion by mischaracterising our reasoning and suggesting it involved the adoption of a presumption in favour of making an order. That was not the tribunal's reasoning, as our decision sought to explain. Nevertheless, it was worthy of consideration by a further court. So not only did paragraph 237 not refer to presumption, but the tribunal clearly did not intend to assume that any presumption existed. They said in terms that was a mischaracterisation of what they had done. The contention that the First Tier Tribunal applied a presumption rests entirely on paragraph 278 of the decision, which is on page 203 of tab 11. And as my Lord Justice Holgate had already identified, that is dealing with the public purse argument, weighing up in that context whether it should be any of the potential respondents to an RCO or the taxpayer who should bear the cost. It was neutral as to the identity of the putative respondent in those circumstances. Therefore, one simply can't get, in my submission from paragraph 278, even an effective presumption, as my learned friend sought to articulate.
Did he not also rely on 265?
Well, he certainly didn't in his skeleton. He does, because my own friend acknowledged that the tribunal was entitled to take into account that SVDP was the developer. It then becomes a question of weight, what is attached to that. But there's certainly no reference to it being a presumption in paragraph 265. Then perhaps less focusing on the words used, but on the effect, Malone Friend seeks to say it's a presumption in all but name. In other words, it has the result of creating a presumption, even if the tribunal didn't think they were applying one. And Malone Friend suggests that the decision leaves little, if any, scope for a potential respondent with means to say that it's not just inequitable to make an order. Well, we respectfully dispute that. This very case shows the variety of factors that were taken into account in weighing up whether to or not to make the order, including that the works were funded and underway. They were just not enough in the circumstances of the case. But to suggest that there's, in effect, that there's little scope for a respondent to defend itself is simply not right. And if one took what Malone and Friend would say would be the most obvious scenario, which is a developer, so let's look at the paradigm case. Where has a developer to go if it's met with an application for a remediation contribution order? Well, we submit even in that case, there is a role for just and equitable to play, or putting it another way, the existence of the discretion serves a function. I'm really giving these examples to illustrate that even in that type of case, they have a function. Not this case, but they provide the rationale for the existence of the discretion. One would be a educational charitable trust who carries out a development to fund charitable work. The FTT in those circumstances would be required to balance the interests of the leaseholders or the landlord, if it was the landlord who was applying against the developer, against the solvency of the charity. That's not a hypothetical example, although ironically I thought of it before I saw the Vista Tower decision, which is a good illustration. You've heard about the two Vista Tower decisions. I'm going to take you to the one in the Authorities Bundle, tab 22. And it's I'll try my chance my arm with a page number 584, which hopefully is a table with Balstraw Limited on the bottom. So just to orientate what this is this was a case with multiple respondents, and at page 578 it is the beginning. I should have taken you to this first, apologies. Page 578 is a schedule where the FTT, in its very lengthy reasoning, sets out what it concludes should be the position in respect of each of the respondents, whether it's just and equitable against that particular respondent. And in the charity context, I wanted to pick up page 584, Balstraw Limited, where the FTT noted this is a registered charity, although it has a subsidiary. And then in the paragraph immediately above, on the next page, immediately above number 23, however, Article 22 is long established. The assets of the charity have been built up slowly over decades. Its charitable status and activities appear a very weighty factor against the making of an order. No specific link with the Vista Tower development was apparent. Those circumstances were not satisfied. It would be just and equitable. Now, this wasn't the developer, it was the associate of the developer, but the point I'm making about the level of discretion nonetheless bites. Another example of where just and equitable might feature in a developer case is where a freeholder has engaged a developer to carry out the development, that the freeholder has retained the lion's share of the profits to be made through overage or whatever. And one can see that if the freeholder is the party who acquires most of the profits, it might be a conclusion to which the FTT could reasonably come that the leaseholders or management company should be chasing the freeholder, or more accurately, for the FTT to make an RCO in favour of the freeholder relative to the developer in those circumstances. So that's those are examples which go to the identity of the developer. One might think of another case, which is where the applicant for the RCO has delayed to a significant degree seeking the RCO. And the progress on civil proceedings were far more advanced than have been the case here. So you're 1 week away from a trial in civil proceedings that will be going on for 3 years. And suddenly, at the last minute, there's an application to the FTT, well, can we have all the money anyway, without having to prove fault under an RCO? Well, one can see there that the FTT may conclude that it's better in those circumstances to allow the civil proceedings to reach their conclusion. Can I then, another example, Vista Tower, if I could come back to that, tab 22 again, page, now page 480. Sorry, that's the first page. So paragraph 3 on page 481, we get the circumstance that the first respondent, Edgewater Stevenage Limited, was incorporated, and R1, the first respondent, commissioned the conversion of the building. So the first respondent is directly the developer. All the other respondents, the multiple respondents who were referred to in that schedule, are all associates of the developer. And then at page 569, well, you just whilst we're in it, but it's on a different point, 567. Paragraph 350. This is on a different point, but just so we don't have to come back to the decision. I thought this court might at least be interested in seeing, it's obviously a matter for this court, but how it's being interpreted in the FTT. The developer is a key target at the top of the hierarchy or waterfall, where no doubt the RCO should be made, and so on. I'll come back to that in a different context. But paragraph 357, the tribunal, this is page 569, the tribunal say that there shouldn't be a presumption, and the test, this is about the associates, and the test that they decide should be applied in determining the extent to which associates of the developer should be responsible is circumstances suggesting additional linking factors, and that will be a fact-sensitive question and a matter for their discretion. So the test that's being applied, we get at paragraph on page 575, the last 4 lines of paragraph 380, you will see that the FTT say the respondents we have included, that's the respondents as associates, appear sufficiently linked for us to consider it just and equitable to expect them to arrange between themselves what contributions should be made. Then at 570, page 578.
Does that mean linked to the developer?
Yes.
Or does it mean linked among themselves?
It meant linked to the developer. We'll see. I'm just going to take you to the schedule, and you'll see the approach that they take. Page 578, and what one sees in the right-hand column of the schedule is a yes or no. So there's an exercise by the FTT of a discretion as to whether to make the associate of the developer pay. So respondent 3, Mr. De Villa, appears to have been a properly declared independent investor throughout, and above the bottom line, we're not persuaded it would be just and equitable to include R3. Contrast, and respondent 22, Balscore, I've taken you to, and respondent 44, Gate Palm Limited, page 593, there was a minority interest and there were not sufficient links. Now, I don't invite this court to endorse any of the particular conclusions. It's fair to say my understanding is that permission to appeal against this decision is being sought and is working its way up through the system. But the point I'm making is that there is clearly a remit and a role for just and equitable to play, both in relation to the identity of the developer and the degree of connection with associates. The other aspect in which the discretion features relates to quantum. Let's not forget that the question of whether it's just and equitable is not 100% of the costs, even if those costs are established. The FTT could decide a proportion should be due. One could posit scenarios with co-developers and RCOs being sought concurrently against both of them, but they have wildly different interests. Now, whether it's just and equitable might go to the question of concurrent joint and several liability, for example, or whether to split it out and make them several and independent of each other. That's a discretionary question. In this case, they concluded that they should be joint and severally liable. But that is nonetheless a step to be taken. And then this, paragraph 381, page 575 of the decision, paragraph 381, we accept the submission from Mr. Hickey that the fair approach is an all or nothing one. We had been concerned about the position of R2, for example. If the RCO is not made against R2, the value of the... So this was an issue where, so to speak, the wrongdoers had a 20% interest in the second respondent. And so the question was, well, would the fair approach be to make them responsible for 20% of the relevant cost? And the point was made, well, if an RCO is not made against the second respondent, the value of the 20% shareholding linked with the families will be missed. However, in view of the amounts involved, the properly declared 70 to 80% shares held by others who appear to be genuinely independent, we do not consider it just and equitable to make an RCO against R2, even if this is limited to the 20% of the total payout. So again, I use this as an illustration of the breadth of just and equitable, all of which serves a statutory function and does not pay lip service, so to speak, to the fact that the respondent happens to be the developer. In summary, the just and equitable discretion is relevant and substantive, even where the respondent is the developer. I do say that the Act, obviously the purpose of the Act, common ground, has to be taken into account, including the whole of Schedule 5, Part 5, I'm sorry. What isn't in the bundle, I think, is Section 1.1 of the Building Safety Act. I'm sure your lordships will be able to procure it, but it is quoted paragraph 17 of the FTT's decision on page 154. Under the heading, the legislation. It's intended to secure the safety of people in or about buildings and to improve the standard of buildings. And my recollection is those are in fact quotes, or a quote from the Act. So in my submission, to summarise, in relation to ground 1.1, no actual presumption, no effective presumption created by the FTT, and section the just and equitable discretion is not merely a thing with the paper not worth being written on so far as the developer is concerned. It serves an entirely proper function. Ground 1.2, the policy of the BSA in relation to developers. Now, there are two linked points made by my learned friend here. The first is, does the fact that the LPI regs that apply between landlords and do not impose liability on a developer who is not a landlord mean that those regulations cannot inform Parliament's intention to make the developer the primary port of call? Sorry, that's quite a long way round of putting it, but the point is that the FTT considered that the existence of the LPI regs, with the developer landlord at the top of the hierarchy, waterfall, can inform the policy of the Act. And my learned friend says, well, that's a debate between landlords. It doesn't inform the policy in any wider sense. And our submission is the fact that the LPI regs apply as between landlords and do not impose a liability on a developer who's not a landlord. Nonetheless, it does inform the overall policy of the Act, which you have to look at as a whole, as has been pointed out. In any event, there are other pointers that show that primary responsibility falls on the developer.
Just before you do, while it's in my mind, I haven't checked the date of the regulations. Are they broadly contemporary with the Act?
I believe so. If not, there's a provision that says that they'll be brought into force. That's we'll check that out.
I see they're made on the 20th of July, 2022.
I will.
Yeah, they did first enter into force on the 21st of July 22.
Yeah.
So that's what I'm going to call the waterfall point. That first question on the LPI regs. The second point in relation to the LPI regs is whether in this particular case, Triathlon against SVDP, it is relevant to the exercise of discretion in favour of making the order sought by Triathlon, that EVML would have had an unanswerable route to claim against SVDP's trustees under those regulations. And I call that the unanswerable route point. So the LPI regs feature in those two ways. So starting with the waterfall point, we have paragraph 265 of the Tribunal's decision, page 200 of tab 11. It's the second sentence describes the policy as being the primary responsibility should fall on the original developer. And we respectfully agree with that. And then that policy, the FTT says, is most apparent from the regulations. So my case doesn't depend on you accepting this submission, but we obviously rely on it as part of the evidence that that was the intention of Parliament. And then paragraph 75 of the FTT's decision. I think this now is common ground, but it's page 166, paragraph 75, about 7 lines up from the bottom of paragraph 75. Right at the end of the line, it says we. We agree with Triathlon's submission that the Act and LPI regulations disclose a hierarchy of liability with the original developer and its associates at the top. And then paragraph 278, paragraph 278, which is on page 203, refers again to the hierarchy, although in a different context. So, as to the waterfall point, the first point is the FTT did not actually need the LPI regs to reach the conclusion that primary responsibility lies with the developer. We submit it's apparent in any event. But, importantly, Malone and Friend has accepted that, or at least does not appear to contest that the policy of the BSA, as concluded in paragraph 265, puts the developer at the top of the tree. It is indeed the policy. That's not apparently challenged. We know that both the developer and the landlord can be specified. That's section 124.3, and I've already taken you to the FTT's observation in Vista Tower on that. They agreed that the developer is a key target at the top of hierarchy of liability. And if one stands back and thinks about it, irrespective of the LPI regulations, it is pretty obvious in our submission that the developer should be primarily responsible if one is comparing him or it to whoever happens to be the landlord of the building at the relevant time, at the qualifying time, or whoever happens to be the landlord of the building at the time of the RCO application. The developer is at the top of the waterfall because none can be more responsible than he. The relevant defect is the direct result of the development works carried out by the developer or on its behalf to build the building. And only to a lesser extent should responsibility lie as an incident of mere ownership of the completed building. And we say it makes common sense to reach that obvious conclusion. We rely in relation to the explanatory notes, as your lordships will have seen, in respect to retrospectivity. I'll come back to that when we deal with that. But we also rely on the explanatory notes as corroborative of the conclusion that the intention is to make the developer pay and primarily responsible. And the paragraphs that we refer to are in tab 14 of the Common Authorities Bible. Paragraph is page 3, I think 392, bottom right hand corner, paragraphs 1010. It's important that, so it's the whole section over there provides the background. This is in the context of section 124, which the topic begins on the previous page. So we rely on that. We rely on specifically paragraph 1011, where the first way in which remediation orders are intended to contribute is by providing a new legal remedy to require developers to pay. So that's your first way. And then at paragraph 1016, the second way in which the remediation contribution orders are intended to contribute is by ensuring landlords meet their obligations. And then 5 or 6 lines down from there, where the developer does not step forward or cannot be identified, and external sources cannot be found, this means that building owners and landlords will need to meet the costs. So again, the notion that the developer is unsurprisingly the first port of call, having built the thing in the first place, it is supported by the explanatory notes. And the example that's given on page 395, the worked example, is a freeholder applying for an RCO against the parent of the developer who developed the building, and unsurprisingly, in a tussle between the freeholder and the parent of the developer, the freeholder is the successful party in the example given. So none of that depends on the LPI regs. I'll say a word or two about explanatory notes because I've just introduced them. Our position in relation to that is consistent with the submissions that you've heard from the Secretary of State. There was, and it is only a matter of history now, but the focus at the First Tier Tribunal had been on the explanatory notes without the distinction having been made about their timing. And the point has now been understood, and therefore the issue is only about, it's still agreed that they're a secondary aid, it's only about what you do with them and the extent to which they provide you with assistance. The one feature which is not in my submission relevant is the, I think there was a discussion about the rider at the front that says these
yes,
have not been.
That seems to be quite common.
Yes, and that definitely is not in my submission a point. That's not the point that's relevant. I can, if one looks at the case of O, which is the Supreme Court case in which Lord Hodge says that the explanatory notes can provide.
Those notes had the same rider, did they?
They had the same rider. If you go to the immigration, we dug it out for the First Tier Tribunal hearing. It's not in the bundle. If you go, it's exactly the same wording as appears in the bit. So that isn't the point.
No.
The point is, in our case, that they post-dated, in substance, they post-dated the Act. So
the rider says the notes have not been approved by Parliament.
yes,
Well, that's clearly true in every case, because Parliament doesn't vote on the notes in any way, it votes on the bill.
that's the point. So it was just because I think there'd been an exchange which I saw on the other day.
You're quite right. I mean, in terms of the timing point, as Sir James was pointing out, and I hadn't noticed, Lord Sales seems to have attached significance to it in Packard.
Yeah. And so the point is, well, we're all agreed they're admissible. We're all agreed that they're a secondary aid. And our submission along the lines of the Secretary of State is it becomes then a matter of the weight that you attach to them.
I mean, the difference is that in the second case, Parliament doesn't have the opportunity to take them into account.
Indeed.
Either way, it doesn't vote. But
Yeah.
obviously,
But
it's not before Parliament at all.
yes, but what we do say is that and we respectfully agree with what the Secretary of State said. These are extensive and detailed notes. They don't have the clout of Parliament, of course, and they're not. They don't have that, but they are written by a sophisticated and informed entity with an overview of the whole of the legislation. They are extensive and detailed, and, if I may say respectfully, clear, if clarity is now one of the criteria. They do provide, in the material respects that I rely on them for, they do provide reasoning insofar as reasoning is required. Sometimes, it's fair to say, it's so obvious one actually doesn't need to see the reasoning. And there is I recognise the distinction my learned friend Sir James made, which is an ex cathedra statement that's unsupported. It doesn't contain any reasons, it simply asserts the position. But one has to read that also in the light of a position where the reasoning is so obvious it actually didn't need spelling out. The explanation for these provisions is given throughout these explanatory notes, a one-off, paragraph 960, I won't take you to it, but a one-off intervention designed to deal with current issues associated with historical defects in safety buildings. All the flavour of these notes, it provides what I would say is already the obvious conclusion that the developer is the first port of call because they are the entity that brought the building into existence in the first place. And whilst the words culpability don't appear, this is not a fault-based jurisdiction. In terms of causal potency of responsibility, they are the first in line because without them there would have been no building. And that's is less causal potency than the mere incident of ownership of the building, which is what the landlord at the given time happens to be.
Am I right in thinking Schedule 8 draws a distinction between ordinary landlords and developer landlords, responsible landlords?
I'm just about to come to the LPI regs, and that's...
But Schedule 8 itself, before you get to the regs, doesn't it draw a distinction between service charges paid to ordinary landlords and service charges paid to developer landlords?
Schedule 8 does the defining. It does the defining that then it tells you who the responsible landlord is, which is then applied in the regulation. So I can take you...
I think I wonder, Mr. Nissen, if we're not
Yes.
falling dreadfully behind, and you're moving on to a new topic, we might break there and start again at 10:30 in the morning.
Yes, certainly. I will, and I'll look very briefly at the regulations, the paragraphs of Schedule 8 and the interplay with the regulations. But yes is the short answer to your point.
Thank you.
Court rise and over.